Welcome our today's speaker. Good morning, everybody in Europe. Good afternoon, everybody who listened to us from China. Welcome to the EU SME Center webinar series today on how to successfully transfer your technology to China. Before we move to the presentation itself and before I introduce our today's speaker, let me first tell a few words about EU SME Center and the services. EU SME Center was established 3 years ago, and its main object, main purpose is to help small and medium-sized enterprises to export to China or to invest to China. All our services are provided free of charge and are available to small and medium-sized enterprises coming from Europe. The services which we offer are divided into the business development, legal standards and conformity, and HR and training. And you can enjoy the services by gaining information and advice, sending us inquiries, checking information in our more than 80 publications, participate in our trainings and the webinars as today. You can use as well information from our databases like exhibition database or the service providers database. We have as well many supporting services like hot desking, we do the matchmaking events and so on. So just to remind you that for those who are new in our webinar, and you are very much encouraged to ask us questions already during the webinar, you can see on your monitors there is a window which is named question. So please type your question, send it to us. Your question will be passed to our speaker, and we will address it either during the webinar or at the end. So now to today's topic about the technology transfer. Technology transfer, and especially for small and medium-sized enterprises, is a very powerful asset. Small and medium-sized enterprises are often generator of new ideas and new technologies, and they can very well financially capitalize on this technology either via the licensing or by transferring the ownership. However, transferring the technology to China brings along the way a lot of challenges, and we would like to address some of these challenges during today's session, and as well to give you some advice and insight of an expert. So, as is our custom, first we start with the poll. And our first poll is about your experience with the technology transfer. So we would like to ask you a question whether you have transferred technology to China ever. First option is no, I have not. Second option, yes, I tried but unsuccessfully. And a third option, yes, and I have succeeded with my transfer. So please vote. And yeah, I can see your votes coming. And a few seconds more. Let's see the results. Okay, I'm now closing the poll and share the results with you. So you can see that 54% have no experience with the transfer of the technology to China. 11% they try to transfer but unsuccessfully, and it would be very interesting as well to know the reasons why you haven't been successful in a transfer. So please, those who are interested in, type the reasons into the question box, and it will get to us, and our expert today will address it during the webinar. And 36% of you have transferred and succeeded. Yeah, so congratulations. And I finish the polls. And finally, I'm going to introduce our today's speaker, Mr. Jan Holthuis. Mr. Jan Holthuis is a founder and managing partner in Hill International Lawyers and Advisors, and he has more than 20 years of experience as a leading counsel, and he advised in numerous Sino-foreign business transactions and represented company in litigation cases. He has published a lot of publications on various topics on the Chinese law, including IPR protection, and presents regularly at leading universities in Europe and China. And just recently, he has been admitted to the list of foreign arbitrators of the China International Economic Trade Arbitration Commission. So, Mr. Holthuis, or Jan, warmly welcome.
Thank you.
And I give the microphone to you, please.
Well, thank you very much, Ludmila. It's very nice to have this experience. I've never done this before, but I must say it's an interesting experience because you're a little bit lonely talking to an audience that you can only see through the computer. I'm a lawyer, and I know many business people always think that lawyers are too much legalistic in approaching problems. I try not to do this today. At least I try to address the business part as well as the legal part, because eventually when you make a technology transfer, you will eventually also make a contract. And what is stated in the contract will eventually be binding between two parties and will have effect if you do it properly. We will come later to the approval procedure, especially in technology transfer agreements. Let me first say something about recent developments in China. Yeah, you can, yeah. I don't want yet to talk about the opportunities and risks. I want to say something about the Chinese government. The Chinese government is very aware and recently has accelerated the need of domestic industry innovation, and they have put enormous incentives on domestic players, but not even domestic players, also on employees in companies to innovate locally, but also to attract state-of-the-art technology import to China. And the aim is to increase high-value production in China and to decrease the use of energy inefficiency and polluting technologies. So that I mention it because in Europe it might be different than with China. In China you have an enormous influence from the government on the economic players, and the regulations in China aim very clearly at the performance of an economic policy. So you should be aware of that. If you are a foreign player in China and you want to act in China and develop business, you can in fact, if you want yourself be active in China and employ employees, you have to register a company and you have to go through a whole procedure in order to make yourself known to the government that you are active. And there are catalogs in China making sectors of the economy, and each time indicate whether the sector you're active in will be encouraged or prohibited or restricted or just permitted, and that is most of the time the biggest category. The same you will see a little bit later in this talk, that it will apply on import of technology and eventually also export of technology, but from China abroad, but that is not the real focus of my speech today. If you consider the success of the Chinese firms lately, then you see that they have an impressive ability to absorb and re-innovate inventions and technologies by other parties. This is something you have to take in mind, because you might think that the Chinese side and the Chinese policy is to attract investment or technology into China, but the real aim, in fact, is to absorb this knowledge as fast as possible and to reinvent maybe the Chinese style new products and bring them again into the market, and that might eventually turn out to be competitors. So you have to take that into consideration, that the long-term aim from China is not to import. Import is the short-term incentive. The long-term aim is to absorb as much as technology as possible that is around in the world and not yet in China. So this dynamic is the frame and the background of the technology transfer. Now, what are the advantages of a technology transfer from Europe to China and then the SME sector to China? One is that you have access to a developing and growing enormous domestic market. So where the European market might have difficulty at the moment, and in comparison the Chinese market is a growing market, and you might bring your technology to generate more money where you cannot do it. Second is that technology transfer to China might bring financial and tax incentives, as written in the sheet, and in particular to China's encouraged industry sectors, which I will deal with later. And technology transfer will increase the reputation of your company's status in China. The government will see that your company will be committed to the improvement of China's environment or technology development, and you might be respected for it. The risk on the other side is that if you don't organize the transfer properly, and I should also say if you have the wrong partner, because you might organize your agreement and everything properly, but you have the wrong partner, then the technology can be exploited beyond the agreed scope and go public in the Chinese market, and then you will eventually miss your purpose. Another, I think, quite impressive risk is that employees of the party who obtains the technology might have incentives to, as soon as possible, improve the technology and then seek independent rights and create a competitor. And the employees concerned might also trick their own Chinese employers, resign, take the technology illegally and set up another establishment. It's a much spoke about risk. I think eventually you will see it, but there are things you can do against it. Another risk is that the Chinese partner might refuse to perform audit and information disclosures, so that you have no control anymore on what is done with the technology. And what is the greatest risk is that if the technology is easy to absorb, that eventually the Chinese side will create a competitor in the Chinese market, and eventually your own products will no longer be competitive for all kinds of reasons, and you're shut out of the Chinese market. So that is the downside of the whole technology transfer. But I still think that there are a lot of positive sides in order to deal with it.
Yeah. And some obvious questions. Our audience, most of them, they are small and medium-sized enterprises. But of course, they are not only ones who. But of course, they are not only ones, the small and medium-sized enterprises, who will transfer the technology to China. So if you have a look at the opportunities and risk, and you compare the large companies transferring the technology into China and the small companies transferring the technology to China, are there big differences in the risk, let's say, or do they face more or less the same risks?
That's a good question. Looks difficult, maybe not so difficult to answer, because the the larger parties have more money to protect themselves. So they be much more careful often to do market surveys, to do check of the Chinese partners, and they might have a bunch of lawyers or advisors who will help them to put everything together, while small and medium-sized companies often are very enthusiastic, seek certain cooperation, and they find themselves, because they have less due diligence and less preparation, find themselves in a situation that could have been avoided if it was better prepared.
Yeah.
All right, we can go to the next sheet. One of the examples I have provided in for today is the experience of GOLDWIND. Well, GOLDWIND and also the parties with whom GOLDWIND cooperated are not small, but it's more about the lesson to be learned here. GOLDWIND is one of China's largest wind turbine manufacturers and fully supported by the government. That means that policies makes the operation for the company easier. They are getting or winning easier government tenders, and as you might know, the wind power market is very much government investment driven. GOLDWIND is an example of a company that held itself out originally by saying to foreign parties, please invest and transfer technology to us because it will open the market for you and eventually you will have access to more projects. Danish and German suppliers eventually did that. They transferred technology. But here there was a co-tandem of the Chinese government and one of their favorite companies, GOLDWIND, in which the policies regulated after these transfers that foreign companies could only be active in the wind power industry by way of a minority share. And up to now, as soon as GOLDWIND had access to the technology, eventually GOLDWIND was much more favored and foreign parties were kept out in the market, didn't gain a substantial presence. So sharing technology and producing it local and starting production locally, especially where you are in the government influenced sector of the Chinese economy, does definitely not automatically open doors in the Chinese market. And in that sense, the analysis whether to make a transfer or not should not depend on what the Chinese parties are telling you, but much more on your own assessment of the situation. We can go to the next sheet. Now we come to the more specific parts of a technology transfer. What is covered by a technology transfer? It's regulated in Chinese laws and regulations, and even the Chinese Supreme Court has issued opinions to make parties explain how these laws and regulations should be interpreted. But anything, in fact, that relates to transfer of Chinese patents by a foreign party. As you know, a foreign party can ask a patent in China. A patent in Europe is not relevant for the Chinese market and territory. So if you want to transfer a patent, you should register that patent in China. So everything related to transfer, that means you transfer the ownership or you transfer the usage right to that patent, and the patent can be an invention patent or plant variety right. It's maybe already very specific, or utility model or design patent. I think the SME Center and also the IPR help desk can provide you an explanation what that exactly implies. But everything related to patent assignment of ownership or licensing is covered by the definition of technology transfer. And then the antithesis of patents, which is the trade secret, is also covered by a technology transfer. What is a trade secret? A trade secret is technology that is not patented, and parties might choose not to patent because, as you know, if you register a patent, the technology will be described and publicly available. You might want to avoid it. Such as Coca-Cola doesn't register anything relating to their formula because they are afraid it will be copied by other parties. But trade secrets are technology and business information which is not publicly known, which have a commercial value, and that is protected by the owner by confidential measures. So if you just give everybody free this kind of information, then it's no longer protected because it has entered with your approval or your negligence, you can say, the public domain. So trade secrets is a right you can only contractually protect. It's completely depending upon an agreement with another party in which the other party is obliged to use this confidential or trade secret information according to the terms and not outside the scope of that agreement. So I gave some examples of technology transfer agreements for your understanding. It can be assignment of patent, but also assignment of computer software, so the transfer of the source code. It can be cooperative design and research, and the definition is very broad. Okay, next. So so I told you that China is a regulated, strongly government-regulated economy, and foreign investment is controlled. So technology transfers have to be eventually, and I will talk about that later, registered, and in some occasions you even need a license. But China has made catalogs. These catalogs are publicly available and issued by the Ministry of Commerce. And it's a very simple list of descriptions of technologies in specific categories. The categories are technologies that are prohibited, technologies that are restricted, and there is a non-restricted technology category. The websites where you can choose the overview are listed in the sheet. The problem is only that in these publicly available websites, most of the description is only in Chinese. But there are translations available in other websites. I think also the SME Center can help you with finding these descriptions. These lists are also updated regularly, depending on the new policy of the government. And it's therefore important that at the time that you enter into such a transfer that you check the list, because it might have several consequences.
Yes, you are right, Jan. We have some links and some translation of our diagnostic kit as well. Plus we have some information on our websites, and we will publish soon a report on technology transfer, which was drafted by Jan. So in a couple of weeks there will be on the websites freely downloadable report on the technology transfer. I will use this break, Jan, to ask you a question which we got from one of our participants, and the question is about employees' risk in disclosing the information. And the question is whether in the Europe, whether China is somehow specific in that risk, like when there are more employees disclosing trade secrets, know-how than in Europe or other countries.
Mm-hmm. The answer is yes. This is a problem in all jurisdictions, but in China the legal system is not as developed as you might you might want it to be developed. So it's not always easy to, especially if you don't document knowledge that employees have during their employment very well, and Chinese companies often do not document very well, and there is that means the legal rights and obligations are often not well documented in employment agreements, and then eventually the employment agreements are, and that's also similar between Europe and China, always explained to the advantage of the employee. That is one point. The second point is that I think employees in China have maybe a little bit more appetite to take risks and take a risk to set up a competitive company, or they might be lured by more beneficial salary packages of Chinese competitors to bring the information. You know, instead of merger and acquisition, I've spoken to some Chinese companies. They say, no, why should we pay, for God's sake, so much money for this company? We better just pay a lot of money to the key employees, and we ask them to come with all the know-how. And there are some parties who say this is the way to do. It's not always working, but if you are in, especially when such a case gets a lot of publicity because it's the Siemens or it's the Bayer or the Philips where it happens, but the smaller parts most of the time can get quite far in doing this, especially if they have very good relations with the local court or the local government. But I should say that the trend in China is that innovations are better protected and investments in technology are better protected for the mere reason that the Chinese government knows that if there is not an improvement of protection, the innovation will eventually have more difficult to take off. And whether China can make it in the coming 20 years is very much depending on the question if they can become a service and innovative economy or not. And I think the Chinese government is very much aware of that they have to make this change, and government policies and laws are supporting it.
Yeah. Thank you. So we move forward.
I give you some examples of prohibited and restricted technologies. It is most of the time, I think, and that's something Ludmila told me before we started the webinar, it's an industry sector that might not maybe directly imply on the SME, but that means that if you are not prohibited or restricted, it's a permitted category, and then the technology transfer is allowed if you register the contract. And that is only, I think, a good development. The lists are not very long, but you can see that some industries like genetic engineering are quite restricted. Pesticide production technology is prohibited. It has all kind of reasons. You see, technology for the smaller engines is restricted for the mere reason that China don't need this technology. They already have it, and they want their own domestic companies to grow and take the mass production. So this list is for your reference only. Whether it's appropriate for your company is only when you check it out yourself. So you have to go through this list or ask somebody to go through the list, or maybe the SME center, somebody can advise, go to the list for you. And then if it's not on the list, prohibited or restricted, that means it's technology you can just transfer to China. There is also an encouraged list. In fact, it is It is technology where you can have specific policy benefits, quick approvals, access to local loans for the importers of this technology. There are subsidies, allocation of land. It's an incentive for the importers to import this kind of technology. If the incentives are very high, then the price the importer is willing to pay for the technology can also be higher. So if it's a very much wanted technology, you have a good position to negotiate a good price. Now, why is this all important? To figure out whether the technology is restricted or permitted or prohibited. It's for the pure reason that if the technology is restricted, or if you don't register the agreement, and we get to that later, then the payment by the Chinese importer of the technology to your bank account in Europe will not be approved. And the import of the technology will strand at customs, because customs will check with every technology whether it is listed and where it is listed, and then determine whether the importer has the right approvals and registrations done. If not, the contract will might even not even be valid. So this is in fact the whole trick, and also the whole way for China to control their economy is to control the payment to the outside world and the investments made by the foreign parties into China. So if we come to the importer itself, I still want to make some remarks, because we have to be in this stage we have to be careful, but also not too careful, because most of the importers will pass the test. You know, you will hear a lot of negative stories about China, but a lot of things are also positive. The technology importer should be licensed and should have a business license that is saying that they are able to import. And normally all parties who see an advantage of a technology import and have contact will say that they have this license, but they might not have it. And they will just sign the contract, and eventually when everything's signed, then they say, oh sorry, we don't have it, but we will figure it out, we will go to the local government, we will get a business license, and you lose a lot of time. And then eventually they might find a third party who has a license, who will then have to accede to the contract. It's not abnormal. It also doesn't mean the whole deal will not go through, but you're going to have a lot of problems, and I think you might lose confidence in what the importer and the party you thought was your good business partner was planning. So better bring this issue up in the beginning, when there is an interest by the Chinese side to the import. You can ask, can we see your business license? And in the business license it should be stated that there is an international trade approval. And then, depending on the technology, whether the technology is restricted or non-restricted, specific licenses are required. And we come to this now. I can go very brief through this list. First, my remark would be that all technology transfers should be registered without exception, whether they are approved or, whether they are restricted or non-restricted. Or only the restricted import technology, they require a separate license from MOFCOM. And this license will be granted after some experts have looked at the technology that's going to be imported. They do it very fast, as you can see. It's within 10 days after the approval, after the application for the license is made. But the consequences are that if there is no technology import license obtained by the Chinese importer, the contract that you signed is not valid, and the importer cannot make any payment abroad for the technology transferred. So this is the main reason to address this this issue. So if you have a non-restricted technology and you do not register that contract, that doesn't mean the contract is not valid. It can still be valid. Only at the time that royalties or the lump sum payment for the assignment have to be paid, then you will find out that there is no registration and no payment can be made, because the banks and SAFE, that is the State Administration for Foreign Exchange and Control, will not allow the transfer, and then you have still to make the registration. Registration is also not very complicated. It can be done online. Afterwards you send out the documentation. And if you do this regular, and most parties do, then you're just in compliance. You should, however, notice that if you do a transfer of a patent or your license of a patent, you have to make a record of this in CIPO, that is the patent office in China.
Yeah. At this point, I would like to encourage you to send the questions even now during the webinar, because we would like to answer them not only at the end. So please do not hesitate. Send the question to us once you have it. And a question to you, Jan. I mean, there is one deadline or one time saying that the MOFCOM will examine the technology within 10 working days. Is it like usual period they will manage, they will keep the deadline, or they can prolong this? How long would the whole procedure would last for obtaining the import license?
Yeah, you will see that some of the in some parts of the process the MOFCOM is in the lead, in the other parts of the process the importer is in the lead. In this case the application is done by the importer, so how much time will it take to make the application? Normally MOFCOM can do it within 10 days. Then it might take a little time before you get the proposal for technology import. Then there is a signing of the technology transfer agreement, and it's back in the hands of the parties. Yeah. Then the technology importer submits a letter of intent and the technology transfer agreement and other documentation. That should MOFCOM will not start with the examination of the authenticity and grant the technology importer before that is done. So you have another 30 days that MOFCOM, after this application has been made, before they give a technology import license. They might ask some additional questions because parties sometimes don't want to disclose all the technology and hide some from the contract or the annexes. Sometimes it's accepted, sometimes it's not accepted. If it's not accepted, you have a communication, then it will take much longer. But in total, it should be able to do it in 2-3 months.
No, that's quite straightforward for the China.
Yeah. Yeah, that's it. Then I would like to briefly talk about the models you can have in a technology transfer, because it's not only a contract, although for medium and small companies of Europe, you will not quickly make an investment and set up an establishment in China. I think most of the time you will enter into a contract. But entering into a contract like the A model is that you transfer to a Chinese manufacturer the technology on agreement, and then the Chinese manufacturer will make the products, maybe transfer them back to Europe, or maybe sell them in the Chinese market. But it's all according to contract. Most likely you have no people on the ground in China to control what the Chinese manufacturer is doing, and very often or very often, regularly, the Chinese manufacturer will produce legally during the day and illegally during the night, and then you will find similar products under a different trade name sold in China without you knowing it. So this can happen, and that is the negative side of such a long-distance agreement. But it can also work if you have a reputable manufacturer who knows that they don't have to mess around with their international reputation, because if it is found out by one party, maybe other contract partners from abroad will no longer use the Chinese manufacturer, so you can earn money on the short but maybe not on the long term. That is one model. The second model is that the transferor will set up, and that's the other part of the equation, a wholly foreign-owned subsidiary who will make the products under their supervision according to a technology transfer between the transferor and their subsidiary, and eventually sell it in China or back internationally. And then in this model you have full control because the employees are in your own employment. You can have a divide and rule strategy that not all employees should have all information, but that only one of your own persons or your own entrusted people will have the whole process of the manufacturing inside, or even not there. This gives you more control, but it's more expensive because you have to set up a company in China. And then you have the third model, that you will have a stake in the Chinese joint venture, that you will, the Sino-foreign joint venture, you say that, with a Chinese party who will most of the time help you to produce the products with a higher technology that the foreign part of the transferor will transfer. And in this case you can partly take the benefit of the profit that the joint venture will make, and you have the right to appoint some key persons in that joint venture. So you will have more control over the technology.
I see. By covering this model C, we answered a question from Monica, who was asking about the technology transfer as a capital contribution to the joint venture. So,
yes and no, because if you do a technology transfer as a capital contribution, it's different than making a technology transfer agreement, because in the agreement you can also decide to license, and the capital is paid up differently by both parties. So if you say we are going to contribute technology to the capital of a joint venture, then immediately you can no longer do the licensing part. You can only do the ownership transfer, because in China they will not accept a not independent ownership right to be used as a contribution in a joint venture. And that is a problem, because if you would transfer the technology to a Chinese joint venture, you yourself no longer own the technology, and you have to have a license back to Europe if you still want to use that technology. So it is a thing we often disadvise to do, or only a little bit outdated technology that's still new in China but not in Europe, because you will lose the ownership. It will go to a joint ownership indirectly. Yeah. So option A, B and C we discussed. Only option B is option C, and option C is option B, because we changed the sheet before. So we can go to the next one. We still have I think 15 to 20 minutes. There are quite some sheets that I have drafted on the technology transfer agreement. I will go through this quickly and only deal with the most important parts. About the Chinese contract party, don't believe in friends in China, but check out, do due diligence, and then become friends, but not the other way around. The contract term is the contract term of a transfer agreement cannot last longer than the ownership right on the IP or the patent that you will license or license to the Chinese entity. So that is a restriction. It's quite normal because after the lapse of the patent term, your right to the patent will also lapse. Go to the next sheet. Yeah.
Just one comment to the Chinese business partner. We have on our websites a lot of information on how to verify, how to do the due diligence and preliminary due diligence on the business partner, so you can check yourself there.
Okay, yeah, that's good. Then the definition of transfer technology. This is key, in fact. We have seen, or I've seen, really cases where there was an enormous, valuable transfer of technology, but that technology was not well described in the agreement. So it was unclear what kind of technology was, and you have it most of the time with trade secrets. What kind of technology was transferred? There were no good records. So if you get into a dispute, the Chinese party might say, oh, but this is ours, and this is what we added ourselves, and this is not coming from you, and this we got from a third party. So if you will not describe very, very careful on what kind of technology you will transfer, what kind of patents exactly, what kind of maybe trade secrets that already imply certain improvements on patents that are maybe 5 years old, then you're doing yourself a very bad favor. Then you have put yourself in a very difficult position when it comes to a dispute. So it's key to be very professional here and have a up-to-date detailed record which technology on which date or even at which minute you transfer to which person, and keep all these emails, keep all the couriers you sent to China, keep all the lists of the employees you gave it to and ask them to confirm receipt. This is very practical but very important, especially when you get into a dispute on whether technology has leaked into the public field. Confidentiality. Confidentiality is also regulated in the regulations as a automatic right, but the confidentiality, and that's important, can last beyond the term of the technology transfer. So that is something you should always draft into it. And equally important, make sure that the employees of the Chinese party who have access to the technology also have employment contracts. You can just ask them, say, I want to see what kind of standard contracts you use, or which employees will have access to the technology, how are their contractual arrangement. Because if the employee is not under an obligation and goes to a competitor, then you will have a similar problem as if the employer, the transferee, would eventually disclose the information.
I can imagine now some of our participants, they are just asking, okay, so I will have a confidentiality agreement, employees will have a confidentiality, but they still can leave. So how, and disclose all the information. So in fact, at the end of the day, how can I enforce my rights if they run away with my know-how to the competitor? Shall I sue the employer, new employer, or the former employer?
No, I think first you will force, or you will make sure that the Chinese transferee will take all actions necessary if this kind of situation happens. So he should notify the transferor that certain employees who had access to the technology left the company. And he should be sure that the employees are not able to take all kind of designs in the evening home. So there should be protection measures within the company, like we think it's quite normal to have it. And when it goes wrong, yeah, then it might be that the employer was negligent. Then the employer should pay damages, and in some cases it's going to be extremely difficult to do something against it, right? So it is in any case important to have the employment agreements in such a way that there are clauses protecting it. Otherwise, you make it too easy for these kind of situations to happen. Mm-hmm. Then payment can be in lump sum or running royalty. I very much are in favor of fixed royalty fees, independent upon the outcome of production, because it's very difficult to control how much products are sold with the technology. It's better that the Chinese party will give an assessment, and afterwards you will get these records, but you should not be dependent upon the calculations by the Chinese party only. We have done a few times that we say, look, if you want to have this technology, Chinese partner, that's fine. How much do you think you can use this technology? So what is the income you think you can generate? And then the Chinese party was very optimistic and said, well, we will generate so much in 5 years. And we said, okay, if that's what you're going to do, then we will calculate already the fixed fee for these 5 years. And then they said, yeah, but we are not sure. So, yeah, but then maybe you're not the right party to deal with. And then eventually they accept it. It's a little bit how much they want to have this technology. But 5% royalty rate in general is an acceptable standard, and the less you are dependent from the internal calculations of the transferee, the better it is. You can, of course, include monitoring provisions, or what also happens is that the transferee will will ask the right to appoint the auditor. Or have a joint right to appoint.
Yeah. Very, very quickly, I launch our second poll, and our question is about the improvements, about which we will talk very shortly on the next slide. And the question is, to whom belong the improvement? It belongs to the transferor or to the transferee, or is shared on an equal basis? And the condition is that in the contract there is nothing said about the ownership of the improvements. So it will be very short. I'm closing now, and I will share the results with you. And 40% thinks that they belong to the transferor, 40% of you thinks the improvement belong to the transferee, 20% believe that the improvements are shared on equal basis. So, Jan, how is it according to the law?
According to the law, you see, this is the biggest sheet, in fact, on the transfer agreement clauses. It is stated that in Article 27, so it's explicitly regulated first, that there is no right to prohibit improvement to the technology. So this is invalid. So you cannot say to the transferee, you cannot improve. That's the first step. And then you will find in the contract law that eventually, if it's not clear who will own the technology in the contract, then eventually the party who made the improvement will own that technology. So then if you didn't regulate in the agreement that you also have a right to these improvements, then you have a risk that you are having no right to be shared the improved technology by the other party. So it's very important to regulate this very well in the agreement, because if you don't do anything, the improvements will be owned by the party making the improvements. If you make a contract clause stating how you want to share these improvements, for instance, that each party will automatically have a usage right on the improved technology during the validity of the agreement, then that will eventually be the predominant factor in the contractual relationship. But in any event, I think you should negotiate a non-exclusive license to improve technology for the Chinese territory and an exclusive license outside the Chinese territory for the uses of your own improved technology. So this is something you should really address in the agreement, and if you don't do it, you will have to take the consequences. I think we have still only a few minutes left.
Only a few minutes, yeah.
Yeah.
5 to 10 minutes.
Warranty and indemnification is not so important because it's you should warrant that the technology you transfer is that you're authorized and that it's complete and error-free. It's regulated by law, so you cannot contract that away. Let's go to the next sheet. Termination is, however, an issue. Because there is one clause in the technology import and export regulations that says that at the time of expiry of a technology import agreement, the transferor and the transferee of the relevant technologies may consult with each other, whatever that might mean, on the continued exploitation of the technologies following the principle of fairness and reasonableness. What does this imply, right? Because let's say that the Chinese party has become fully dependent in their own survival on the technology because they have certain products in the market, they have a lot of employees hired, they made investments in a plant, and eventually the technology transfer is, and the license, let's say, is terminated. What happens then? We didn't find case law. I know I once did a litigation that lasted three years on this question alone. But in that contract, that was an ABB contract, it was stated that after the termination, the other party had the right to use the transfer technology, but had to pay a reasonable fee, but did not have the right to improvements of the technology. So this is an issue that will often lead to difficult cases. I saw another contract which is all lawyer paradise but a disaster for the clients, in which the transferee of trade secrets at the end of the license agreement patented all the technology, and at that time the technology in these different territories was no longer available for the transferor himself, and he had to enter into all kinds of legal battles in order to keep the right to use its own technology. So with transfer rights, it is a very tricky issue. Dispute settlements, don't stipulate in the agreements that your own court and your own law will apply. It has no meaning, because if the infringement is in China, you will have no access to Chinese courts anymore, because the foreign courts' judgments are not executed in China. Arbitration is a different issue. That's why you find many model clauses in this kind of agreements, because arbitration awards can be enforced in the countries that have signed a special treaty. It's called the New York Treaty. China signed that, and most European countries also signed that. So arbitration is the way to go. Tax liabilities, I will skip that matter because we have no time. Then clauses you have to avoid. I think eventually you will get access to the sheets or also to the booklet that I've written for SME Center, so you can have a look at that too. Unfair competition. How much time do we have left?
We still have like 5 minutes, I think we can do.
Okay, because unfair competition is a very interesting thing. There is an article in the unfair competition law saying that managers, but it's wrong translation. What is written in Chinese? In Chinese, it's written market organizations or market players. They should not use the following methods to infringe business secrets: to steal them, to disclose them, or to violate the contract and eventually permit others to use them. If they do, they commit a wrongful act. Now, it has been often the question that if a employee or a key employee would, or a company would set up a different company and start to use the technology that they have learned in accordance with the contract that was signed with a foreign party, if they use this technology and produce new products based on the technology and of which the profit they do not share and they do not honor the terms of the agreement, whether that is illegal or not, the answer is, in principle, yeah, that's illegal. However, if a third party would buy your product, would take it apart, study it, and then eventually come to the conclusion that he can reproduce it, then, and he reproduces that, so that's the re-engineering part, that is legal in China. I'm not sure whether it's legal in Europe, but anyway, in China, the Supreme Court has issued an opinion saying that if you obtain technology legally from the public field, you study it and then you can reproduce it, then it's reverse engineering that is not infringing this specific article. I have also, and it's on the next sheet, made a stated a case that is quite famous in China. It's going back already to 1996. But if you read this carefully, you will find that if it's clear that the new company could never have re-engineered the technology, and in this case it were two old engineers of a company that developed technology over years. They reproduced a new product in 3 months. Then the court said, yeah, that's not convincing. We will not allow it and you have to pay damages. So, last two sheets, I think, the business recommendations. With respect to strategy, and then I come back to what I said in the beginning, understand the short-term priorities, which is stimulate technology transfer, but also understand the long-term goal of this whole policy, which is to absorb this technology, and then make a clear long-term risk analysis with respect to the technology that you are planning to transfer, right? So how vulnerable is your business in the long term of this technology, and is this technology that you transfer replaced by your own innovations in a few years, so that you have still an advantageous and advanced position in the market with respect to that specific technology or not. If not, you have to really consider whether you want to do this, or maybe you sell it for a very high price, because you can put yourself out of business if you are not very careful. Then it's very important to check the up-to-date lists. We have indicated the websites where you can find that. With respect to the Chinese partner, do a due diligence. Don't believe anybody, but just check everything yourself. It's not so difficult to do the check. The information is not so difficult to retrieve. And take a step-to-step approach. So first do the smaller cooperation. If things go well, payments are done properly, you have good communication, you have the feeling that you're really having a reliable business partner, then you increase the substance of the technology transfer. And then with respect to the cooperation terms, I think apart from the arrangement to deal with how you deal with improvements to the transfer technology, you also have to make, and I see so many mistakes in this, a very detailed technology transfer control, so that it's very clear that you were the originator of the technology that is going to be transferred, to whom you have transferred it. You have to keep detailed records, make clear in which emails you send it or how you transferred it. This is really key. Without it, you cannot even start to provide evidence that the technology is yours when it comes to a difficult cooperation. And I think, yeah, that's the most important. Thank you a lot for your attention.
Thank you, Jan, very much for the excellent presentation. We could just spend, many hours probably talking about different aspects of the technology transfer. So thank you again for coming here and sharing the experience with us. Just for your information, as I mentioned already before, Jan drafted for us a publication about technology transfer, which is going to be published on our websites in the coming weeks. This webinar recording will be as well available on the YouTube, so please visit our website, which you can see, and type technology transfer or similar keyword, and you will find the webinar, and it will forward you to the YouTube. Thank you very much for attending the webinar, and I look forward to meet you on the next session.